Mr. Hart.
Thank you. May it please the court. Thank you for the chance to say what I guess I should have said to the Court of Appeals. This case at this point, I think, is about state legislation passed in 2010 regarding the rates to be paid to providers of medical services under the Iowa Medicaid program for services that were provided during fiscal year 2011, which was July 2010 through June 2011. And until the Court of Appeals decision, there really was no dispute about what that 2010 legislation meant. Everyone understood it to mean that the Department of Human Services was to continue the rate cuts that it had put in place during fiscal year 2010. The case did not arise because there was some dispute about what that legislation meant. The case arose because the Department of Human Services screwed up its administrative rules seeking to implement that legislation. And the department's argument throughout this case has been that despite the inadvertent omission in its rules, it was correct to continue the full reduction in its payments to this group of providers pursuant to the legislative mandate that was in place. Now, the Court of Appeals' response to that argument basically was that the reduction in these payments to this group of providers did not follow inevitably from the 2010 legislation because that legislation referred to rate cuts, quote, as specified under Executive Order 19.
On that point, Counsel, does the record reveal whether DHS met the 10% standard that Executive Order 19 imposed, even without this 2.5% inflation factor? In other words, do you see what I'm saying?
The short answer is no. There's certainly nothing in the record about the effect of this.
Should that make a difference in our analysis?
I don't think so. I mean, it seems to me the legislature pretty clearly directed that the rates to these providers, that the rate cuts put in place in 2010 for these providers should continue in 2011. Well, as a matter of fact, this isn't really about the 10% cut was for 2010. We're talking 2011.
Yeah, but the original cut was for 2010. I mean,
right.
Right. So your interpretation of what HF 2526 says in effect is DHS shall continue the reduction in payments to program providers in the same percentages that it followed once it was told to make cuts under Executive Order 19 in effect. Is that what
Sure.
That's a rough translation of what you're saying, right?
Yes.
All right. So, assuming that we interpret the legislature that way and not the way the Court of Appeals did, you have an old regulation that predates HF 2526 that required a higher payment to the provider. So your argument is when it says DHS shall continue the reduction, DHS's statutory obligation is to follow the legislation and not the prior rule. Is that what you're saying?
Exactly.
Okay.
Well, that's certainly a plausible interpretation of the spring 2010 statute. But I go back to, it seems to me, another plausible interpretation of the statute, which is a directive to do what the Executive Order 19 specifically told them to do, which is to cut 10%.
Frankly,
right? So I guess I come back to this question. Why shouldn't we be focused on whether DHS did that, even without this 2.5% inflation factor for these providers?
well, I don't think that interpretation makes much sense for a couple of reasons. One, the executive order was for the 2010 budgets. You know, the executive order was agencies, everybody decrease your budgets by 10% for 2010. So for the legislature, and this legislation was passed in 2010, but it had to do with the 2011 budgets. So for the legislature to say, so the legislature is now passing a new budget, brand new budget for 2011, based on new budget figures. For a legislature to say, as part of this brand new budget, reduce your brand new budget by the amount that the executive ordered you to reduce last year.
So what you're
Take
saying
your brand new
is
budget and reduce it by 10%?
what you're saying is DHS would have added, and there might be some programs that are different, there might be new programs, there might be other things, and so you're saying that when it says in the percentage amount applicable to the respective provider, that wasn't going to get you 10%, even if you use the same percentages as before.
Well, that would be another, that'd be another point.
So you couldn't say in the percentage amount applicable and still get 10%.
Well, and I'm also saying the new budget is based on new budget projections. Why would the legislature say, here's a brand spanking new budget based on our best new budget projections, but reduce it 10%? That doesn't make much sense. And it also completely ignores the language, referencing not reduce your entire budget, Department of Human Services, but reduce payments to providers in the percentage amount applicable to the respective provider. I think that can only mean continue the reductions that were made pursuant to, and the word is under Executive Order 19. If I had it to do over again, and I was asked to draft it, I might maybe pursuant to Executive Order 19 would have been a better word than under, but I think that's the only meaning that you can give it, is continue the reductions that were put in place pursuant to or under Executive Order 19 in the year that Executive Order 19 had its
Address
life.
the other argument, sort of the one the district court relied on, which is the legislation is not self-executing. So if DHS didn't adopt a regulation covering this specific category of providers, by default, the old regulation would continue as to the method of payment.
Well, and I think this legislation is clear enough to be considered self-executing. As I've already said, I don't know what else it can mean other than, and the legislature said, the department shall continue the reduction in payments to medical assistance program providers for the new fiscal year in the percentage amount applicable to the respective provider as specified under Executive Order 8. Apart from the perhaps confusing reference to Executive Order 19, excuse me, apart from the perhaps confusing reference to the executive order, you've got the department shall continue the reductions. I don't know, why that shouldn't be considered.
To be clear, though, if it said
self-executing.
continue the reductions taken because of, under sort of seems, gives life to your opponent's argument that the 10% goes there, and we can't rewrite a statute.
Well, I could write a better statute today. I could write, continue the reductions put in place by the Department of Human Services pursuant to the rules adopted on this date pursuant to Executive Order 19. That'd be better.
Do you find the statute ambiguous, so we need to start doing that, or is it pretty clear when it says under?
In context, I don't think it's ambiguous, and as I said, everybody understood it until the Court of Appeals decision. The ALJ, who heard this case, understood it. The providers weren't arguing that it was ambiguous or that it didn't mean continue the reductions that were put in place pursuant to Executive Order 19. could it have been written better? Sure, but, you know, the hurly-burly of legislation, particularly having to do with the budget, you know, it isn't always the most finely crafted document you might wish for. And I do think it's important, a couple things I wanted to emphasize. I do think it's important to bear in mind that the department did not just somehow blow off its administrative rulemaking responsibilities in this case. It did seek to adopt administrative rules implementing this legislation. And in fact, you could see this case as the department getting into trouble because it tried to write a much more specific rule than it had relied upon for the first fiscal year that this cut was in place. The rulemaking notice for 2011 was 22 pages in the administrative bulletin. Unfortunately, it missed this one piece of this reimbursement methodology for this one provider. And as the Court of Appeals stated, that was an inadvertent omission. But the department did not just somehow blow off its administrative rulemaking responsibilities. I also think it's important to bear in mind that the department would have fixed this problem, or the district court perhaps could have ordered it to fix this problem with its rules. But by the time the problem came to light, it was really too late to do that. This problem didn't really come to light until appeals started to be filed about these rates. And the first appeal was filed in December of 2011. By that time, it was the middle of fiscal year 2012. By that time, rates had been changed again, in fact, eliminating this cut that had been put in place.
There isn't any argument by these providers that they relied on the prior regulation, that they understood that's what they were going to get paid.
I don't think there can be any plausible argument that there, frankly. Not only did, I mentioned the 22 pages of rulemaking, that rulemaking clearly stated in the preamble the department's intent to, quote, continue the rate reductions instituted in December 2009 pursuant to Executive Order 19. And as Mr. White has pointed out in one of his briefs, there was also an informational letter sent to providers. And that letter informed providers that the rates that the department was in the process of promulgating at that point would, quote, will make the 2.5% rate reductions ongoing, close quote, for fiscal year 2011. And that letter also specifically noted that the inflation factor that's at issue in this case would be reduced by 2.5%. So I think the department made quite clear what it was intending to do and what it in fact did, which was to follow the legislation and ignore the inadvertent omission in its own administrative rules. One concern that the Court of Appeals seemed to have was the rulemaking, you know. Isn't the department, and this court might also ask, isn't the department required to write rules about this kind of thing? And well, I would have to answer yes. The department is supposed to write rules, and the department tried to write those rules. But it's also required to follow any substantive legislation that the legislature might pass about reimbursement rates or anything else. You know, and the case shouldn't be about somehow trying to teach the Department of Human Services a lesson or punish the Department of Human Services for screwing up its rules. At least I would submit that the issue should be, okay, given the rules that were in place, what rates should have, in fact, have been paid?
It strikes me that might be a distinction between two situations. One would be where the department is taking some affirmative action and hasn't adopted a rule to enable it to do that, affirmative action is just relying on the legislation. And perhaps a situation like this, where you have a provider that is claiming it's been underpaid and then is relying on a rule that is, at least if you're correct, contradicted by subsequent legislation. Those might be two different situations. Would you agree?
Well, and there are cases where the legislature directs the department to adopt rules. I don't know if that goes to what you're asking, but in the same piece of legislation we're talking about, in fact, there was a directive. This gets a little long, but there was a directive: the department shall request a waiver, that's from the Federal Medicaid Agency, to add assisted living services to the home and community-based services waiver for the elderly. Upon receipt of federal approval of the waiver, the department shall implement assisted living as a service. The department shall adopt rules to implement the approved elderly waiver assisted living service. That's section 11, subsection 22. Under that language, I would say assisted living doesn't become a service until the department figures out the details, gets a waiver from the federal government, and adopts rules. But that's not the kind of provision we're dealing with here, to my mind at least. You know, the provision we've got here, as I've said already, is the department shall continue the reduction in payments. It seems pretty clear to me that the legislature intended those payments reductions to continue. I see that my time is expired.
Thank you, Mr. Hart. Mr. White.
Thank you. May it please the court, counsel. Through the process, and this is often the case when you go through the administrative process and then through district court and court of appeals, with all the briefing, I think over time this has become maybe a little more complicated than it needed to be. The case and the issues in this case are fairly simple. It all begins with the fact that the Iowa Code clearly states that it is the Department of Human Services by rulemaking procedure that sets Medicaid payment rates.
Yeah, hypothetical on that. Let's say DHS had a pre-existing rule that said we're going to pay $35 an hour for these services. The legislature adopts House File 2526 that says DHS shall pay no more than $30 for these services. DHS doesn't adopt a rule saying it's going to pay $30, but it pays your clients or your client $30. Do you have a right to sue for the extra $5?
If the statute that addresses the payment rate that you're talking about, Your Honor, is specific in both what that rate ought to be, what service it applies to, and the fact that it needs no further rulemaking, in other words, if it is not ambiguous, then yes, I think that statute would trump as the more specific conflicting statute with 249A4. That's not what we have in this case. We don't have a conflict between two statutes or two law provisions. We have 249A4 that specifically says that the manner in which payment rates get set is by the department's rulemaking procedure. Then we have HF 2526 that says, here, department, here's our directive to you to adopt rules to implement some type of payment.
But it doesn't say rules. It says, shall continue the reduction in payments in the percentage amount applicable. I know the other argument about, under Executive Order 19, but it doesn't say you need to adopt a rule in order for that directive to become effective, does it?
Well, it certainly implies it by way of a couple of things. One is our obligation or our doctrine to seek harmony between legislative provisions. And the second is by the text of HF 2526 itself, which states, here, continue the rate cuts, and if you like, you can even use emergency rulemaking procedures. And the district court relied on that quite a bit by saying, okay, well, just as a matter of legislative interpretation, I can see clearly that that means that the legislator contemplated that this was going to require rulemaking by the department. Now, there was discretion from the legislature to the department as to whether it could use normal rulemaking or emergency rulemaking, but not discretion as to whether it could use rulemaking at all.
I mean, in essence, I mean, you need without rulemaking, your client in effect doesn't. If there had been no rule at all, your client would get paid nothing, right? I mean, or some kind of quantum merit, right? In order to get any payment, you need to have some kind of legal basis for doing so, right?
Right, the rate has to be set by some legal basis, and unless and until the legislature does something clearly, like in your earlier hypothetical, that basis is by departmental rulemaking. And we have the pre-existing rates that the department was intending to cut by this not complete rulemaking that it engaged in. So there are rates that we were to be paid. It's the fact that the department cut one aspect of those rates that obviously we're taking issue with.
Counsel, if we assume for the sake of discussion that we find ambiguity in the 2010 statute, one of the things we focus on commonly in interpreting ambiguous statutes is the purpose of the statute. I think a fair reading of the statute would suggest perhaps that what the legislature had in mind was just to impose the status quo for the next fiscal year. Why isn't that a really reasonable, plausible interpretation of the statute?
It is a reasonable and plausible interpretation of the statute that the legislature was telling the department that it wanted the department to continue the rate cuts that had been in effect through the rulemaking procedure. So the resistors have never looked at HF 2526 and said, oh, we have no idea what they're talking about. That's not the point. We looked at it and said, well, clearly this doesn't change the fact that it doesn't change the indisputable doctrine that it requires rate-setting rulemaking procedure to change the rates. And I think one of the crux of the department's argument, or the crux of the department's position, is finding ways to get around the fact that 249A4 states that the way rates get set, cut, changed, or otherwise, anything, is by way of rulemaking. And one of the ways is to say, well, there's a conflict now between HF 2526 and 249A4. They're not. They're in perfect harmony with one another, because HF 2526 is saying, okay, here you go, adopt the rules. And the fact that the department mistakenly failed to follow the directive in its entirety doesn't change 249A4. Nor does the department's failure to follow the directive entirely render 2526 meaningless. I think that's one of the other arguments of the department is, hey, look, the way the Court of Appeals has ruled, HF 2526 is meaningless, and we want to avoid any rule, or any ruling, I should say, that renders a provision meaningless. Well, the Court of Appeals decision does not render it meaningless. If somebody directs me to do something and I don't do it, I may have consequences to suffer myself, but that doesn't render the directive itself meaningless. So I think that
Do you think your position would be clearer or stronger if the legislation had said, instead of shall continue the rate reductions, it said shall adopt regulations to continue the rate reduction?
Well, our position would be clearer, but it wouldn't. We don't need that for our position to carry the day, because, I mean, the legislature could have done one of two things, and it did a third thing. It could have said rates for this service will be this dollar for this period of time. Okay, the legislature can give in 249A and take away in another provision, certainly. It could have done that, it didn't. On the other hand, it could have done what you just suggested, which is to say, black letter, and now go forth and go through your rulemaking provision. It didn't exactly do that either. What it did do was closer to that end of the spectrum, though, by saying, we want you to continue these rate cuts. If you want to, you can use emergency rulemaking provisions. There's no other way to read that than to conclude that the legislature knew that the department needed to use rulemaking procedures to implement this rate cut. And all of this begs the question of, if it's so crystal clear that this is a self-effecting provision, HF 2526, why would the department have engaged in any rulemaking? It wouldn't have needed to under what their argument is now, but obviously they did engage in rulemaking, they just didn't do it correctly. So we think that the perfect harmony between the two statutes, the only way to, we think, rule the case, or rule on the case that preserves the integrity of 2526 and 249A4 is the way we're suggesting.
I mean, in the big picture, you agree your clients are getting, if the Court of Appeals is sustained, kind of a windfall, right?
Well, we're not getting a windfall, and this came up both, I think, at every level, and that is the department taking this position of, well, almost as if we're trying to take advantage of a nice little happenstance situation. Well, without getting inappropriately snarky in this venue, the Medicaid providers in this state have a pretty long and painful history with the Department of Human Services holding our feet to the fire to abide by the absolute letter of the Iowa Administrative Code. For the department now to come forward and say, oh, yeah, we forgot, but come on, no harm, no foul, you knew about it. That's
In the regulation said right at the beginning, the reimbursement rules for particular providers are amended to make the same reductions. And then when you went through the list, they messed up. They didn't amend all of them, right?
well, that's correct, Your Honor, where it counts in the effect of, in putting the rule into effect, they did not amend all. That's correct, Your Honor.
Reading from the preamble, not the rule itself, I understand, but, okay.
Yeah, that's correct, Your Honor. I think another argument the department makes is that this is the same, and this was addressed by the court in counsel's discussion as well. The other argument that the department makes is this is exactly the same as an agency taking some affirmative step that is clearly beyond its power or beyond its mandate. And that's where the department gets into the Lenning and Merchants cases. Lenning was a case in which the court noted, or this court noted in passing, that a rule that does not comport with enabling legislation may be abrogated as an act in excess of the agency's authority. Well, that's not what we have here. We don't have an affirmative act of putting a rule into play that is clearly improper that this court can strike down.
Well, what if that had happened? What if let's play with the facts a little bit. What if DHS had adopted a rule that happened to give your client a 2.5% adjustment in the base rate and in that other base factor, contrary to what the legislature said? Would you be able to rely on that rule?
I think we can rely on the rules as they're properly passed and written.
So you can rely on the old rule because it was properly passed at the time, but you couldn't rely on a new rule enacted after 2526. Is that your argument?
I'm not sure I understand that follow-up question.
Well, here's let's say hypothetically, instead of the situation where your client is relying on an old rule that predates 2526 that had the 2.5% in it, instead your client's relying on a rule that DHS enacted contrary to 2526 that included the 2.5% increase and didn't include the 2.5% reduction. Would you be able to rely on that subsequent rule to collect payment?
We could, unless and until this court struck it down. This court or another court struck it down. And I think that's one of the differences that makes it not analogous when you have an affirmative act on the other, on one side, on one hand, and what happened here on the other. I mean, in other words, I think that rule could be struck down if challenged. But
Isn't that in effect what we're doing today? We have a case in front of us. We're being asked whether we follow the rule or follow the statute, right?
well, but that's not the same choice as do you strike down a new rule or do you not strike down a new rule? Because if the court believes that it has a choice of either following the rule or following the statute, it has to have first concluded that the statute itself can be a self-affecting rate change. We don't think you even get to that choice. We don't think there's a judicial remedy to get what the department wants because we think there has to be a rule, an administrative rule that states it, and this court, while it can strike down a rule that's been adopted, can't go back and rewrite a rule to implement, for instance, a rate cut. So we don't think it's the same situation. But we think it all begins and ends with the fact that unless and until a sufficiently specific statute comes by and changes the notion in 249A4 that rates have to be set by rule, rates have to be set by rule. The final issue, or one of the final parts of the department's case, is significant reliance on this Wyoming Mining Association case that the department, I think, quotes from a great deal. We lay out in detail in the briefing why we don't think that applies. I mean, even if it were controlling, why that would not support the department's position. So with that, we believe that the Court of Appeals and the district court were correct, and that the department did not have the authority to cut that particular rate, and therefore the case should be remanded to the agency to recalculate rates. Thank you.
Thank you as well, Mr. White. Rebuttal, Mr. Hart?
Mr. White relies quite a bit on the fact that the legislature gave the department emergency rulemaking authority as part of this legislation that we've been talking about, and I want to point out a couple of things about that. One, as noted in my reply brief to the Court of Appeals, the emergency rulemaking authority that was in the 2010 legislation applied to a lot more than just the continue the rate reductions provision that we're talking about here. And some of those things actually allowed the department some discretion about what exactly it was going to do. So that's point number one. But
What does the authority say? Can you read it?
At the end, there's a long code section addressing, or I shouldn't say code section perhaps, but a long section of this legislation addressing various providers. And then the very last subsection says the department may adopt rules to implement this section. This very long section addressing very many things. And then there's a new section, emergency rules, that provides emergency rulemaking authority for anything.
Language is may, not must.
The department may adopt emergency rules to implement this section. Correct. And as I said, that applies to many more provisions than just the one we're talking about today. And maybe more fundamentally, I want to be clear, I'm not arguing, because I've been accused of arguing this, I think, maybe not today, but in the briefs. I'm not arguing that the legislature somehow abrogated the normal rulemaking requirements that apply to Medicaid rates. That's not what I'm saying. I am sure that the legislature intended the department to do two things for fiscal year 2011. I think the legislature intended the department to continue the rate cuts that had been put in place in fiscal year 2010, and the legislature intended the department to adopt rules to that effect. Mr. White's position is that because the department failed to do one of those two things correctly, it can't do the other one either. My position, I guess, basically, is that, 1 for 2 is better than 0 for 2. We're going to do one of the two things, even though we screwed up doing the second. Mr. White's also cited the Wyoming mining case, which he didn't note this, but it does. The Wyoming mining case kind of dovetails with his argument that 249A.4 of the code is key here, because that provision of the code generally provides that the department shall adopt rules to set Medicaid rates. And his response to Wyoming mining is that, well, Wyoming mining, that involved taxation, and that is, quoting Mr. White, in the realm of the legislature, while this case involves Medicaid rate setting, which is, quote, in the realm of the department. Well, I guess it's true that the Iowa legislature has generally given the Department of Human Services authority to set Medicaid rates through administrative rules in a way that it has not generally given the Department of Revenue any authority to set tax rates. But to the extent the legislature chooses to dictate the rates to be paid in the Medicaid program, I think that remains just as much in the realm of the legislature as anything else the legislature chooses to address. And that's what the legislature did in the second year of this budget crisis. It said, I think...
I just had one question, just going back to what you said a minute ago about the implementing sentences there. So did they have two implementing sentences? The department may adopt rules to implement, and then they may adopt emergency rules? Are they two separate implementing sentences there? Or I guess I was confused. I wrote down one, and then you switched it to emergency. So.
It's a little... there's a section, and this is all in Chapter 1192 of Iowa Acts, 2010 Iowa Acts. Section 33 is medical assistance and other, actually, reimbursement rates. And as it goes on for quite a while, and the final section of that, or the final subsection, I should say, of Section 33 is the department may adopt, actually, that does say the department may adopt emergency rules to implement this section. If I left out the word emergency before, I misspoke.
Well, I think the first time you left it off, and then you added it the second time. That's why I was confused if there were two separate implementing sentences or not.
It's definitely there.
Thank you.
I misspoke the first time. The department may adopt emergency rules to implement this section. Then there's a separate section that provides some more detail about emergency rules, providing if the department adopts emergency rules, we have to bring them to the legislature rules review committee and stuff like that. So, thank you.
Thank you as well, Mr. Hart. The case then is submitted, and the bailiff may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.